Good afternoon, friend. I, Dr. Sujata Kadam Dungare, presenting on the lecture of contract. The topic is essential of a valid contract. Okay, everyone know about the meaning and terms of the contract. The term contract is derived from the Latin word, which is contractum. It means drawn together. It is an agreement entered into a contract between two parties. Two parties should be there. Essential of a contract. As a contract is something more than an agreement. Therefore, it is said that all contracts are agreements, but all agreements are not contract. To constitute a contract, there are some conditions should be satisfied. If we are going to say this is a contract at that time, essential of valid contract we should prove. Number one, two parties. Two parties means in the type of contract, in any type of contract, to constitute a contract, there must be an offer and acceptance. The person who offers or makes offer is called offeree, and who accept is called acceptor. Then consideration. There should be consideration between two parties, which is acceptor and offerer. Capacity to contract. The parties to the contract must be competent to enter into a contract according to Section 11 of the Indian Constitution Act. He must be major, he is of sound mind, he is not disqualified by law, and free consent should be there. According to Section 13, the Indian Contract Act, two or more parties are said to consent when they agree upon the same thing in the same sense. Capacity to contract and lawful consideration should be there when the parties are going to agreement. Legal relationship. A contract to be enforceable, it must certain legal relationship between the parties. It is discussed about in under the following cases: Balfour versus Balfour, also discussed consideration and legal relationship, lawful object and legality of object. A contract to be valid, the object for which has been entered into must be lawful. Then terms must be certain. Terms must be certain means the terms which is included in agreement should be certain to understand both the parties. Free consent. Free consent means what? Free consent means the consent which is given by the acceptor should be free from undue influence, misrepresentation, coercion, and coercion. Their capacity to contract. There must be a competent person to make a contract. In Mohri Bibi versus Dharamdas goes, in these in these Mohri Bibi versus Dharamdas goes, in this case, exactly meaning of legal capacity of the contract. Minor should not be involved directly in contract. On the behalf of minor, anybody can make a contract with them. Okay, thank you, friends.